about collecting information about students, and now we'll turn to issues regarding the use of the information once it's been collected. I assume that there is no problem with the school using the information once it's being collected.
Yeah, when we talk about use of it in itself, um, it's the kind of thing that you need to think about it at the time you're actually collecting it. As I said before, the question to ask is why? Why are we collecting it? As long as you're using it for that particular reason, there's no problem, no consent needed, because you've dealt with that right up at the front. If, for example, you need to have contact information for a student, there's a good reason for having that. So once you have that, yes, the school division can use that information in whatever way the division deems necessary in order to protect the child and to provide education. That doesn't necessarily mean that everybody gets to look at the information. It's very important that the board, again, you're going to get tired of hearing me say this, but procedures and protocols, putting those in place is very, very important. Um, Only those people that need that information to do their jobs is who should have access to that. One of the examples that has come up is with electronic student data systems. We've had questions come in from administrators who say that all the teachers on staff want to have access to all the student information all the time because you just never know when you might need it, when you might have to contact somebody. Well, just because you might need it is not a good answer to the question, why are we collecting it? You have to think about other ways that it can be handled and restrict the contact information, I'll just use that as an example, to those people that are the most likely to be needing it, and then you make sure that other staff members have access to that individual if they need the contact. For example, if the school administrative assistant, if the principal, if the selected teachers have contact information, you maybe have 4 or 5 people that have access to that for every student. The teacher might have access to their contact information for their own home class, and if they need it for somebody else, they have 4 or 5 other people that they can go to. So if the administrative assistant's off sick, there's still somebody else that can access that information. So that's the kind of thinking that needs to go on at the school when we just say only employees needing the information to do their jobs. That's easy to say. The practicalities of working that out sometimes are a lot more difficult to do, but that's what we have to do to make that a realistic statement. One of the things in terms of talking about use by the school division that comes up is, we talked a bit before about medical reports, for example, who gets to use those. But you also get into some sensitivities with psychological assessments or other kind of learning assessments. Parents can get very demanding about some of that information, and sometimes we have them saying, no, I don't want anybody else to see that. I want you even to take that off the file. That is, I mean, it's a difficult. If we then the school can use that information without the consent of the parents. The parents cannot block the use, appropriate use of information. Now, of course, if we don't share it and don't have proper security and we don't share it properly, it's not properly secured, then the parents, they have every right to complain and come after the school division. But if we're using it properly and for the proper uses, then that information can be used in whatever way the procedures and protocols of the division are set up.
So let's talk a little bit about access by the student. What right does the student have to access his or her own information?
Well, this is interesting because under the LAFOIP, what it says is it's the individual whose information it is who is the person who has the right to access that information. So if we apply that to the student, well, if it's the student's personal information under the Act, the person who has the right to access that information is the student. It doesn't set any age limits on it. And we'll see later that that parents do have some right to exercise the right of the student, but the student themselves, that doesn't take away from the right of the student himself or herself to access his or her own information. Now, generally speaking, it's not an issue. Most students aren't, they leave that to their parents. They're not concerned about it. Um, you might have a couple reactions. You might have the smart aleck student who finds this out, and the 12-year-old that comes and says, I want to see all my information. If it's a frivolous, silly request, then in that situation, I think boards can deal with that appropriately, or the teachers and students. However, you may get other students who want to access information, might be serious about it, and some of it you might be able to share, past report cards, things like that. There is sometimes, however, like things like psychological assessments, for example, that a child who isn't mature, who has access to that information, any other kinds of assessments, comments by teachers, that can be, very harmful to a child's, perception of themselves, their mental health even. So the Act, LAFOIP, does provide for that. They do allow an exemption to access in situations where it's believed that it may be harmful to the individual's, safety, health, or mental health. That may apply in many instances for children. In other cases where kids are sincere, the way I would suggest handling it is if it makes sense, is to work with them and their parents to go through and sit through the stuff. And again, ignoring those kids that might be doing it just to try something on.
Students who are 18 or over would be considered adults. Do they have to consent to release of their information?
Yep, they're adults. They at that point in time, their parents, under the Act, actually don't have any right to access the information, and they would be treated just as any other third party. This mostly, would be sort of the kids that turn 18, and I know in many cases schools still, have parents come in and talk to the parents, or the parent phones in and asks about the kid. Um, I don't want principals or school staff to start getting worried about doing that. In those kind of situations where there's no problem, the kid doesn't raise an issue, even though the Act doesn't really allow implied consent, it's the kind of situation that's so low risk that I think a board, a staff could just carry on doing that sort of thing, even though technically under the Act you would require the consent of the 18-year-old to talk to the parent about them missing school for a day. There may be those other instances where you have those 16-year-olds living on their own, 18, 20-year-olds, 21-year-olds even get the consent from those.
Information of the student.
Under 18, as I said, the student has the right to access, but what the Act says, what LAFOIP says in Section 49, is that the parent can exercise that right, the right to access, as long as it's not an unreasonable invasion of the privacy of the student. It's a very specific section. That's the only way the parent gets to exercise. It's the only section of the Act that gives the parent any right. So it's the same right as the student would have, subject to the same exemptions and the same sort of thing. So the parent or guardian basically just steps into the shoes of the student in doing that.
This seems that it might impose some fairly significant restrictions on sharing information with parents. Maybe you could give us some examples of where the school might decide it should not share information with parents.
Well, in the majority of cases, 95% of times, it's not a problem because parents are there in order to, help their kids and further their education. But there are sometimes where it's generally the behavior of the parents that might be an issue, where the belief might be that this would be an unreasonable invasion of the student's privacy. Kinds of things that might occur there would be a parent who is not really involved with the student on a day-to-day, but is just trying to seek some information for their own purposes and not in order to help the student. And in that kind of case, I mean, it's difficult sometimes to tell, but that given the fact situation, and I have a high degree of trust in the opinions of principals and staff who deal with families and students to know when those are the cases um, that might be occurring. The other example might be a parent who previously had information and misused it by either disclosing it inappropriately or perhaps treating the student inappropriately when they got the information. Um, there could be also some situations where you might jeopardize the services for students. I guess the best example of that might be a situation where the student themselves has asked for counseling, and if the parent knew about that, the parent might, put pressure on the student to stop it. And in a case where you have a student who's old enough and who's, frankly, any student who says, I really need counseling, I think we need to listen to them. And so that would be another example where we do it. So generally, bad behaving parents.
Right. Thank you. I suspect there may be some times when students under 18 might not want the school to share information with parents. Does the school have to agree, for example, not to show the 13-year-old student's report card to his parents if the student says he doesn't want the parent to see it?
Well, again, I go back to that. If that 13-year-old has figured out a way where he gets out of having to tell his parent what marks he had, that's not a good enough reason. That he might say it's an invasion of my privacy. Well, yeah, but you know what? We're trying to help you get services. Your parents are working on doing that. So in that kind of situation, I certainly would advise the school division to go ahead and share the marks. However, there might be situations where you have students that are mature enough for me, and whether they understand the subject matter that is might be released or requested, and whether they understand the implications of not sharing. Uh, so if they've got to a point in their life where they're, and usually we're looking at least a 12, 13-year-old, but more likely 14, 15, certainly if you get to 16, 17-year-olds where usually this happens in situations, maybe custody and access, where one parent might be fighting the other and using the information in ways that really are not good for the child. Um, those are the kind of situations. Perhaps you have an independent student who's living apart from, I remember one example we had was a 16-year-old girl who'd moved out of mom's house because mom was using drugs and mom's boyfriend was dealing drugs, and she didn't want mom to know where she was because she was afraid that what mom's boyfriend in most part um, would do. So in that case we would say, of course, we're not going to share that information. It's not in the best interest of the student to do that. So there are those kind of situations that do arise.
Okay.
And I guess, in those kind of situations too, the school can also consider the seriousness of the situation and whether there's other help available to the student and the student's own background. The examples that have arisen here are sometimes where a student of sufficient years might perhaps admit to a counselor that they're sexually involved and want to go see a doctor. Um, well, do we have to tell parents that? The student says, no way, well, how old is the student? Are they getting help? Are they getting counseling perhaps from the the other services? Do they have an app that they've confided in? I mean, all those sort of things can be taken into deciding whether and how to release information to parents.
Thank you, that's helpful. I understand that parents have the ability to access educational information about their children, and I assume that this extends even in the case of divorce, where parents each have custody of the child.
Absolutely. The both custodial parents, if they have custody, they both have education decision-making power, but they also have access to the education information of the student. It's different if the one parent has neither custody nor access, so no contact with the child at all through court order usually. In that situation, that parent who has no access does not get any information. In the case of a parent who maybe has joint custody, but may not have joint custody, but has access to the child, or the child perhaps resides with them, or they have visitation rights with the child, as long as there's some form of access by the parent, that parent has access to the education information of the child. So they would be shared the same as with any other parent, newsletters, report cards, ability to talk to teachers, meet with teachers, that sort of thing. So they can go ahead and share that. It's still subject to LAFOIP, so just the stuff we were talking about earlier, we certainly wouldn't share information that we thought was an unreasonable invasion of privacy of the child, but they would be entitled to any other information as any other parent would get.
So can you explain what happens in the case of a parent who does not have custody of the child? Do these parents have any ability to access the records of their children?
Yeah, and that's what I mean by sort of a person who would have access. So they don't have custody, but there's actually an act that covers that. It's the Children's Law Act, and it specifically sets up a section that says they can have the information even though they don't have any custody.
Okay. Yeah. Thank you. So we've been talking about parents, but the Education Act and LAFOIP both use the phrase parent or guardian. What would the term guardian mean in the context of access to information?
There's actually some definitions under the Education Act that help us a bit with this. And for education purposes, the Act says that a person who has lawfully received a child, the child is in their home and they have the care and custody, so they're looking after the child. They're not just staying for a sleepover, they're there and they've taken on custody. It's also defined as a person who be recognized in law as a guardian.
Thank you. I think it's important to also discuss some of the other types of persons who might want to have access to student records.
Oh, you know what? Before we move on to that, I just want to add a little bit about the guardianship. Because I mentioned that there's these definitions, but we also get occasions where we get informal guardianships, I'll call them. You can have an order for guardianship that is a formal court order that says so-and-so is a guardian. Those are not that common, actually. And more commonly, you might get a mother who's perhaps having some trouble with a 14-year-old boy who wants to send him to uncle so that uncle can work with the kid. In those kind of situations, what we suggest that schools do is get something in writing from mom that says, I have custody of this kid and I want my brother to have custody of him for a year. Just to have something on the record. And this is very frequent. If you know the family and the background, it's a lot easier to do that. The only time I'd be a bit cautious about something like that is if you have a new family moving into the neighborhood, you're not sure where this is coming from, and you want to maybe do a bit of inquiry into that to make sure that there's not a situation where there's potentially something behind it, like a custody dispute or an abduction thing. I mean, that's very rare, but again, just something to be reasonable about. We also have situations with social services. They can get orders for guardianship, and those orders put the guardianship in social services, who then delegates to a foster parent the care and custody of the child. So for the purposes of the Education Act and LAFOIP, we would treat the foster parents the same as we would the parents, the natural parents.
And those letters or documentation could be housed in the cumulative record?
They probably should be there, so
Okay.
that it's that we understand who the contact people are, and how to deal with the child if something should happen, so we know all that history of it.